My name is Michelle Brinkman, and I'm the Chief Deputy in the District Clerk's Office, highest level trial court clerk of Austin, Texas, Travis County. I want to welcome you to this session focusing on help for self-represented litigants. I'm going to introduce the entire panel at once, and then we're going to get started. You'll be hearing from all of them. I'm going to start at this end. A colleague of mine, Lisa Rush, who's head of the law library at Travis County. She started her schooling over at Texas A&M and finished at UT with the Masters of Library and Information Science. In Texas, when you go to both A&M and UT, you are considered bi-educational. I also hold that designation, so Lisa and I have that in common. She's going to share what's going on in Travis County to provide assistance to self-represented litigants. Then we have Marcus Reinkensmeyer, whom many of you know, I'm sure. He has been in court administration for many, many years. He did his undergrad work as a Spartan at Michigan State.
That's correct.
And then you finished at Illinois?
Correct.
Okay. With his MPA. He left the administrative job of Maricopa County and now is with the AOC of Arizona. And I know personally that you've won many awards and recognitions, which you should be acknowledged for in your leadership in the entire field of court administration, and I appreciate that. Now we also have, excuse me, Jennifer Murray. And Jennifer, you hail from Maricopa County as well, is that not correct? And she is, like Lisa, the head of the program that provide for the law library and the self-represented program. She has her her JD, correct, as an attorney, and also her education, I believe, in library science. So both Lisa and Jennifer have that in common. She's going to share with you what's going on in Maricopa County. Then finally, who is going to kick off our panel? David Slayton, our esteemed chair of NACM. And David is the what we call the administrator for OCA, which is Texas' way of spelling AOC. And he's been in that job, what, about a year and a half or so? He hailed to us from Lubbock, Texas, where he got into court administration. And I will also say that both Marcus and David are fellows of the ICM Institute for Court Management, and I had the privilege of going through that program with David back in 2007. So I'm going to go ahead and turn it over to David first, and then the rest of the panel, and I appreciate your being here and your interest in providing these vital services to a very significant customer base that we all have in the court system. Thank you.
Michelle, thanks very much. What a kind introduction. Welcome, everybody. I think we should actually have a round of applause for you folks. You are the diehards. You've made it through with the impending storm, so thank you for being here. And I just want to tell you, for me, this is such a critical, kind of timely session. There's been all kinds of progress, I think, over the years with the self-represented litigants, and yet I just have the sense there's so much more to do. And so this morning we heard a little bit about court access and whatnot. And this panel, I think you're going to find they have got so much head knowledge, some very good practical tips they can share with you. And when the panel finishes, we actually have kind of a guest cameo appearance from John Grecian will join us and kind of give you an announcement about some possibilities on the program side as well, even some funding possibly. So stay with us if you can for the session. So I don't want to take too much time. I'll just tell you my background in this was, I guess, first as court administrator, but maybe on a personal note, I'll just tell you my mother is a law library director, has been, and my father-in-law was a university law library director. So I guess I kind of grew up with all that. And when I look at people like Jennifer, I just, great admiration for the work they do there. These folks wake up in the morning, I think, to serve and to help people, and that really is true. So part of what I think you hear at Maricopa County is where they tried to blend those library services with self-services and trying to help folks with navigation. In terms of the unrepresented, I think there's been all kinds of studies to this point. I think you folks are aware, but the barriers to justice are just kind of numerous, really. The cost of litigation, the complexity, the different locations. The hours of court never seem quite right. The geography, I know in Arizona, you could sit in your car for 3 or 4 hours just to find a courthouse or a library. And so how do folks overcome that? And I think we're going to find that the library is one way to kind of help with that. There's a study just recently, Triage Protocols for Litigants Portals. This is a National Center study funded by SJI. It's just fascinating, and I'm going to read, just, if you don't mind, just a couple sentences which I think will kind of help set the stage. In studying this issue, the Research Committee of Self-Represented Litigation Network found that courts generally lack formal protocols for helping litigants to find appropriate assistance. Does that sound familiar to you folks? Just to find their way in the front door. Instead, courts make decisions based on available resources or intuitive decisions about individual litigants by court self-help staff. The need for formal triage protocols that could be used by both litigants and court staff is evidence. And while many legal services and programs and self-help centers use checklists to screen and sort cases, these have been designed only to meet program needs and do not consider broader systemic issues. So I think that's really a good background, or a good backdrop. And so with that, we're going to first hear from the panelists. I've asked each of them to kind of summarize kind of their background, their perspective, and then after that we're going to go into a kind of a quick question and answer with the panel. And we've left some time here for you folks to throw questions to the panel as well. So make some notes, challenge these folks a little bit if you will. And I'm going to lead off with David if I can. You have his biography and whatnot, but what a unique background. Served as that trial court administrator, one of the first courts, I think, to actually implement the trial court tools standards years ago, and now serves as that state court administrator for this enormous state of Texas. And so, David, I'm going to ask you to kind of, if you can, share your perspective on self-help and also how the libraries can help in that context.
Thanks very much, Marcus. And once again, thank you for all being here today for what I think is a tremendously important topic for us, and will continue to be more and more important to all of us as court leaders to consider how we address a growing and rather large issue that's quite important. You know, I was sitting here thinking about kind of how to start this, and I think today's a great example, and many of us have had the experience that I'm going to be talking about, maybe fresher on our memories than maybe it would have been otherwise. You know, if you think about the fact that, let's say that today you were being forced to fly somewhere, and you called to get help, which maybe many of you have done today, and you have to wait on hold for a long time, which maybe many of you have done today. And then whenever you get through to someone, you start asking them questions because you don't know what you're supposed to do, and they basically tell you, I'm sorry, I can't help you with that because that'd be considered advice, but you figure it out for yourself, go online, find the right tools you need, and then you show up to the airport. Maybe you're able to figure that out. You show up to the airport and there's no signage, there's no one willing to assist you because, you know, that would be legal advice and we can't do that. I mean, that'd be airport advice, and we can't do that. And yet you're trying to put yourself in a situation where you can get where you're wanting to go and solve a problem that you perhaps have, but yet there's really no one there to really give you the type of assistance you need. None of us would find that acceptable, and we would not be flying with those airlines if that was the situation. But yet, many times in our courts across this country every day, citizens who are needing access to the courts for whatever reason, many of whom who don't even want to be there but are being forced to be there for whatever reason, are put in that same type of situation where people are not willing to assist on phone calls because, after all, we all hate pro se litigants, right? And so the general impression is the fact that they're really difficult and that we just really don't provide the type of service. So yet we're responsible as courts of providing access to justice, but oftentimes I think we put our citizens in a position where it's impossible to access the type of justice that they need. So just to give you a little bit of my perspective on this, I, as Marcus said, started off working in the trial courts in Lubbock County in West Texas, and actually started off in the basement of the courthouse, filing documents in court files during college. And of course from there started seeing people who were there needing just information. I remember the person who came in who wanted a copy of their divorce decree, was a self-represented litigant, who had filed the case many, many years ago and had since remarried, only to find out that she had never actually been divorced. That was a challenging conversation to have with someone who thought they were divorced and now were remarried. I'm not sure how that conversation went at home, that in fact she was still married to the first husband. So obviously lots of perspective from that point of view. Shortly after that, I began working in a court, just as what we call in Texas a court coordinator, someone who worked in a specific court scheduling cases and working with litigants every day and attorneys every day. And obviously, as many of you know who deal with this every day, people desperately need help. They want to do what they're supposed to do, but yet they don't exactly know how to go about that. And so we began to see this as a growing issue in the court I was in. And at the time we were just kind of getting introduced to it and working with it and trying to figure out what to do. In the meantime, I went off to federal court where I was in Dallas, Texas, and was responsible for the pro se litigation section of the office. And so most of it was prisoner litigation, which was obviously challenging in its own way, but really anyone filing cases by themselves, that was something we worked with. So I began to get some more experience dealing with individuals needing assistance in some way. And then finally I went back to be the trial court administrator in that county in West Texas, Lubbock, Texas. Lubbock is a county of about 280,000 people, so it's a fairly large county with a large number of filings. And we began to look at the research and see that about 20% of the individuals filing, especially in the family law or domestic relations part of the caseload, 20% of them were representing themselves, and that was really not looking at the child support cases, where of course that number is even higher when you look at the Title 4D federal enforcement, where many of the respondents are representing themselves. Those were actually not even counting those cases. So a lot of people were doing it, and we began to see that that number was increasing every year. If we went back and looked statistically, we would see every year it would go up. Then we began to look at, okay, are these people who are indigent? And so we began pulling those type of records and seeing that not all of them were. And it began to sort of paint a picture that this issue was continuing to grow, and that in fact not only were people who were indigent representing themselves because the fact that legal aid programs were not staffed sufficiently to be able to handle their cases. Just as a side note, the legal aid providers in Texas are only able to handle 1/5 of the need. For individuals who actually qualify under their guidelines, they can only handle 1 in 5 people who walk in the door. And the only ones that they're handling at this point are basically domestic violence cases on the family law side. Anyone else just needing assistance in the courts, you're on your own. So we began to look at this issue and how we could address it. And we started working very closely with the bar. And this is something I would say, as if you're beginning or looking at trying to increase the access to court services, do not leave the bar out. Some places in Texas, and this will kind of get when I start talking about state court administrator perspective on this, places where the bar has been left out, there's been tremendous resistance and quite frankly backlash to any sort of programs. But yet when you engage the bar and get their assistance up front, it seems like there's been more success. So that's just a tidbit I would add right here at the beginning. So we began to work with the bar in Lubbock and came up with a number of programs. We actually put together a panel of attorneys, some of the high-powered attorneys in Lubbock. The attorneys were just there every day, sort of taking the smallest cases, and also the legal aid providers. A law school, Texas Tech Law School, is in Lubbock. We got them engaged on this and began to do a number of things. And one of the first things that we were able to do was to, in fact, engage the law library, and you'll hear some more about the ways they can help today. But they were tremendously helpful because a lot of times when litigants show up to the courthouse, where do you send them? And one of the places that we could send them was to the law library. In Lubbock, the law library is supported from filing fees, but primarily overseen by the Bar Association. So once again, another way to collaborate with the bar. The bar in Lubbock, actually, we convinced them in sort of an interesting way to apply for a grant to put kiosks in the law library that would allow litigants to have interactive forms where they could begin to fill out documents and receive assistance in that way. So the bar was the one who actually got the grant and oversaw the project. So how can they complain about it if it's their project, right? So that went really well. And so we also established with the law school a program where Individuals who were not able to be seen by the legal aid programs could be referred to the law school to see a clinical. The law school has a clinical program in family law where they're able to, third-year law students are able to represent individuals under the supervision of an attorney. And so they began to get some practical legal advice, legal experience as attorneys, but also be able to meet a need. And so that formulation ultimately ended up in having a night court, because another issue that we all ought to consider when we're looking at access to justice is these individuals who are some of the lowest end of the economics sector are the ones we're asking to take off from work, come and sit and wait at court, and miss their job, which is probably an hourly job, by the way, and they're not getting paid when they're not there. So we established a night court where basically one night a month we would schedule all these cases, and they would come in, and a judge and a clerk and all the support staff would go over and actually hear cases and get those resolved. And that has worked really well. So a number of things were done in Lubbock. I think there are still plenty more to be done. The court administrator for Lubbock, who replaced me, is in the back of the room, so I know he's probably still working on these issues. But it's a big issue that we faced in Lubbock, and took a number of things to do it. But having a judge who was passionate about it, which is something we had, one of our judges was really passionate about doing it. She was the one who oversaw the night court. Her name is Judge Judy, so appropriate name there. But also a number of lawyers. That was great. One of the other things that the state did is, this was actually before I got to the state level, but has continued, is really trying to look at a statewide way to address this need, because there are even places in Texas where those numbers of self-represented litigants as petitioners in family law cases exceed 40–50%. I think you'll hear perhaps that Maricopa is quite a bit higher than that, but there are obviously more and more people who are doing this. And as John actually said in a board meeting, the NACOM board meeting on Saturday, John Grecian stated that, you know, no longer should we be thinking about these self-represented litigants as individuals who are poor. They are also people who choose this method. And part of the issue, I think, in the legal community, and especially in the court community, has been, well, if they choose that, that's their own stupidity and that's the way it is. But we have to realize that that is what people are doing, just as many of us choose to self-medicate whenever we get sick rather than going to a doctor. You know, WebMD is out there for a reason, because all of us try to figure out what we have and medicate it ourselves, the same way that individuals are taking their own legal matters in their own hands. So we've got to think about that a little bit. One of the things that Texas began to look at was a set of forms that could be adopted statewide. What Texas found was that judges were refusing to accept handwritten documents for filing, were refusing to accept any form that had a checkbox where it was done, were basically just making it as difficult as possible for self-represented litigants. And so the Supreme Court of Texas began to look at a project where they could adopt forms. This is the project where the bar was not engaged up front, and as anyone who followed this project in Texas knows, it was quite difficult for the Supreme Court and for the legal community as a whole to get to this point. But the Supreme Court did adopt a set of forms for unrepresented litigants that had uncontested divorces with no children and no property. That's as far as we've gotten on that, but that's where we're at right now with that. But one of the things that was interesting, one of the most compelling things that we were able to do to convince the Supreme Court to adopt the forms was to actually show them that if you go on Craigslist and you search for forms, legal forms, things like that, we were able to show that all over Texas. I think I gave the Supreme Court a packet of documents this thick of things I'd printed off over a 2-week period where individuals were selling forms and selling their services for hundreds of dollars to self-represented litigants. And it was literally forms that were available for free on some courts' websites, including Lisa's website. So there was this sort of market out there that was really kind of fleecing self-represented litigants. And so that's a step that's been taken. At the same time, one of the things that we're looking at, you heard me, if you were in the morning session, mention that Texas is now a mandatory e-filing state for civil and family for attorneys, not for self-represented litigants, but it's available for them if they choose to use it. But the problem in there is, how do they get the forms they need? As all of you know, many times self-represented litigants look for forms and they find them wherever they can. Barnes & Noble, internet. For Texas forms, they use Indiana or Tennessee or who knows where else, forms that don't comply with Texas law. And so one of the things that we're working on right now with the bar is a way for them to use the e-filing system and also have interview type questions that will allow them to produce a form at the end that can then be automatically e-filed straight out of the system. So we're really excited about that project and where that is headed. I think the key for me from this perspective is we need as courts to engage all of our partners. This is a problem that is not going away, and we really have to make sure that the bar and the courts and anyone else that we can get as partners on this are engaged with us. I also think that as courts, we need to begin to think of these people, and I know Marcus used the word, and I've already used it once, as we've been calling these people self-represented litigants, or SLRs. There's a new term that's going around now that people are starting to use of unrepresented, which I actually like better because, as you know, self-represented litigants don't really normally do a very good job of self-representation. And so, in fact, they really are unrepresented litigants. They have no one representing them. And so how can we assist them as much as we can and still preserve the neutrality of our court process? That's where our partners can come in and really help us. So those are the basic things kind of from a perspective from both working at the trial court and working at the state court. These are tremendous challenges. They will continue to grow for us, and we must be prepared as a profession, as court leaders in this room. You and I must be prepared to really take a lead in this and see how we can assist with the problem and really look at it more as an opportunity for us to be able to solve the issues that are before us. So I'll pass it off and help answer your questions later on.
Yeah, thanks very much, David. You can see where that local experience, I think, really will help at the state level. I love your comments about the stakeholders as well. So we're going to bring Jennifer up next and talk to you then about a local library that works with the court. And one distinction I'll make is we set up in Phoenix or in Arizona, these libraries are actually part of the court system, so Jennifer actually would work in court administration. I think in a little bit we're going to hear from Lisa where it's actually more of an executive branch function, also working with the court and with the Bar Association. But it tells me there's no one way to do this. There's a number of different governance models that will work, and they both have achieved just great ends, if you will. So Jennifer, you're up.
Hi, everyone. Again, I want to reiterate, thank you for coming today. We really appreciate your attention. And I wanted to start out with just a brief audience participation, and I'm going to do a word association game. So the word I'm going to say is library. When I say library, what do you think of? Books, exactly. And that's why we're here today, because we are so much more than books. And I think that hopefully after spending a little time with myself and Lisa, I don't think Lisa has heard me speak before, but I know I've heard Lisa speak before, and she is, not to set the bar too high for her, but I know that she's a good public speaker. Hopefully you'll have a little bit of a different perspective on libraries after you leave today, and that's our big objective. Because for me, when I think of a library, I think of information. And when you're a law librarian, that means legal information. And that's what we're all trying to deal with every day with self-represented litigants. So Maricopa County, as Marcus said, is set up with a specific model that may not be applicable to all of you here. And so one thing I want to say when we get to our panel section, get to questions and answers, if you have a specific situation in your area, for example, you're rural, I think we still have a lot of thoughts and ideas on how to participate with your public library system, even if you don't have a law library. I suspect you have a public library, and I think there are still collaborative opportunities with any type of library, be it law library or non-law library. So with that said, I'll go ahead and start with an overview of what Maricopa does. Obviously, Maricopa County is a urban county, 4.5 million residents approximately, and as a result, we deal with a lot of self-represented litigants. And I think this is probably true for most courts, but in our family court arena, we have probably between 80 and 85% of our litigants are self-represented. So one thing that our library does, and when I say library, I know that many of you are probably familiar with our self-service center in Maricopa County, which opened in 1995 and was the first self-service center in the nation. When I say library, know that the library, as Marcus already alluded to, is joined with the self-service center now. We're having a bit of an identity crisis, and we're trying to figure out a new name for us. So when I say library, feel free to, if it's easier for you, replace that with self-service center, because at this point they're really exchangeable terms. So we do have library personnel that work on forms. We have a manager over our forms unit, 2 law-trained staff that deal with maintaining and updating our forms, and another administrative assistant who deals with the basically paper processing and uploading of forms to the internet. And that is not enough for us, actually, and we're about to make the case for needing more people. We have over 800 forms, if you include our information packets as forms as well. That's just in English. We also maintain them in Spanish, so most days it feels like we're just behind on trying to keep our forms up to date and current, but my goal is always just to get people their foot in the door. So we are doing form production for the court, and not just in print, but also in an electronic format on the web and through a intelligent form system that we've developed in-house called Easy Court Forms. It used to be called eCourt, and then we got a cease and desist letter, and we changed the name. So we have trademarked Easy Court Forms, so you're going to have to go find your own name if you're looking for something to brand yours. So lesson learned there. Evidently, you do need trademarks in government occasionally. And we also just started a new service for forms assistants where our staff who are law trained and work on the forms, and this is a pilot for us, are meeting with the litigants on a limited basis. We have blocked off a couple of afternoons, and they will meet for a half hour. We have blocked off an hour, but we tell the litigants it's a half hour for assisting them with completing their forms. The objective is that they should have their forms as complete as possible, and they're coming to us with specific questions. That's the objective. It's a pilot. We're still working out some kinks, but it has been a positive response. And we are, I was just talking with Michelle from Los Angeles County earlier. We're about to go in March through the assistance of a National Center for State Courts grant to the Los Angeles County Superior Court to look at their Justice Court program there to see if that's something we might be able to model. Interestingly, our staff also have some assistance with this pilot from our family court. We have a early case resolution system there where we have law-trained attorneys who meet with the self-represented parties for some differentiated case management, and when both parties are self-represented in family court cases for pre-decree matters. And we have some of our, we call them family law case managers, meeting with the public as well. So it's not just an effort that the library's taken on. We have partners within the court that are assisting us to get that pilot up and running and get the data to hopefully bring in a Justice Corps program of our own. And that really leads me into the court navigation concept. Even if we don't call ourselves this, our library functions as court navigators. Our staff help people navigate the court. And so because we are located within the court, it's a regular question we get is where to go for different things. And we have 3 regional courts where our staff are as well, and they're actually the information desk. When you walk into the regional courts, the first thing you see are self-service center staff, and they're probably 80% of their job ends up being navigation related. And we also offer a lot of training. We do computer-based training for computer research, of course, but also for a lot of the court services, e-filing. Because we have the meeting room facilities, we also do presentations in the library. ideally, and I put down lawyer presentations in the library because I'm hoping that some of you won't have the problem we have where we're actually not able to, because of our court solicitation policy, have lawyers in the library doing presentations. But we do have government attorneys come in and do presentations. One of our most successful is a restoration of civil rights workshop for people who have been convicted of felonies and want to have their rights restored. Arizona doesn't expunge. So the conversation this morning with the plenary speaker was amusing because we have people, that's a conversation I have with people every day, explaining that, you committed this felony and you can't just make it disappear now. So that hit close to home for me. But it's been a very successful, positive workshop. And so a lot of times the library can help you by being faculty for those types of presentations. And when you launch a new collaboration, I think one of the first things you'd think of is PR and how are we going to put this out there, and you start to make this really nice flyer. You can just make business cards. It's easy to do. If the pilot tanks, you can have a library business card, and that still can be used for library business card purposes. So that's actually how we ask the court to make referrals to us, is just simply by providing the departments with our business card and making sure that they understand what we can and can't do. And it's just a simple referral. And we all like to give somebody physically something so that they leave with a good referral. And we found the business cards to be the simplest thing. Recently, and I'm really curious to see how this pans out, but we got library funding. There are federal library funds for library services and technical assistance, and the state library got a grant for us to engage in training with the public library system. So we're piloting this in the Phoenix metropolitan area, where we've reached out to certain cities' library systems, and we are doing a 4-month-long, once-a-month training session. We meet about an hour to 2 hours a month with public librarians and give them information, training about the court system, the law. And our objective isn't to make them law librarians. Our objective is to enable them to make a good referral. And that's what I think I keep coming back to is, this referral concept where the public are going to end up places that you don't expect, asking questions about the court system, the motor vehicle department and the vital records department, whatever these entities are called. And I know every state likes to call them something a little bit different, but the litigants end up other places asking questions. And in order for us to have a cohesive network, it's about enabling each other to make referrals to other systems, and those connections are extremely important. And I believe that, and we'll see how this plays out, I believe that the public libraries are getting more questions than we probably expect, and engaging with training in them and finding out what questions they're getting and creating that dialogue with them is going to go a long way. And there's also the added advantage that they have hours. I mean, I know that we used to have a night court. I know David talked about night court. That's a great thing. But with the economy and when we encountered the first economic crisis, night courts went away. And so we're 8 to 5, Monday through Friday. People do not, as David alluded to, have their legal crises, Monday through Friday, 8 to 5. Most often it seems like they're having them, at midnight and then coming in, the next day, trying to deal with them. Everybody always laughs, but Super Bowl Sunday, that following Monday is always a really big day for us. There's a lot of drinking going on, and we invariably have a lot of people coming in. You think it's the holidays, but we find Super Bowl Sunday, that following Monday, to be one of our highest traffic days. So I think that the libraries are open on alternative work hours, and it's another way if you can start creating that partnership where things can happen outside of Monday through Friday, 8 to 5. And so what we're going to be doing in this partnership with the libraries is bringing attorneys in and doing workshops on the next law day in May. So we're really interested to see how this works, and our goal is that this will be something that we would then replicate statewide to the rural areas, so that it's not just the metropolitan area that benefits from it. And I like to think that it'll have even larger, more significant application and impact in the rural areas. The last thing I wanted to mention about our specific model before I just show a few screen captures of what we actually do in Maricopa County is this concept of embedded librarianship. Our library is by default embedded in the court because we are part of the court. We are funded by a percentage of filing fees in Maricopa County, and we are actually a department of the court. I think that is not the normal law library setup. There may be a relationship, but not all of them are under the umbrella of the court. It has its pluses and minuses, comes with a lot of ethical obligations that sometimes stymie some of the creative things we'd like to do. But we are embedded in the court. For law libraries or public libraries that are not embedded in the court, this is the new hot button, hot buzzword with libraries. This is embedded librarianship concept, and everybody is wanting to try it. So if you went to a library and mentioned embedded librarianship, it would probably get a Pavlovian response where they would get very excited because it is the kind of the du jour phrase for librarianship. And we unfortunately or fortunately already happen to be doing it, but I wanted to mention that because it really does, by putting the librarians where the need is, I think you're better able to start establishing those connections. So think about that concept as we're going through our talks today. Just some really quick screen captures or pictures. We're about to do some significant re-engineering with our department, so when Marcus asked me to include some pictures, and my initial reaction was one of embarrassment and not wanting to provide screen captures, because when I say that, and I mean this with no disrespect to anyone in our organization, but when I say that we were created in 1995, we're also still stuck in 1995, and we're working on it, but it's taken us a little bit to get out of that workflow model and do the re-engineering that we need to do. So when you walk into a self-service center, this is what you see. On your left, you'll see our display packets, and on your right, you'll see our self-service center counter. And you, like any good self-represented litigant, would probably be very confused which way to go. Do I go to the packets? Do I go to the counter? You go to the counter, in which we tell you you have to go look at the packets and then get back in line for the counter. My hope is that in 2 years I can come back, I can do this same presentation, and this will be the before, and I'm going to be able to show you the after, because I have a very specific vision of the after. And it was interesting to me that David would use the analogy of airports, because that is, the self check-in at the airport is really part of what my vision is, where it's kiosk, touchscreen based. The kiosks are intuitive navigation with touch screens. I think if you throw a mouse in front of people, they freak out if they don't know how to use a computer. But if you tell them they just have to touch, it makes it a little easier. So we have a lot of great ideas, and I just want to say, stay tuned. And I think that in a couple of years, there'll be another program where we're talking about what we were able to create. The website we also just redesigned, and so I think if you haven't take some time and look at our website, because I do think we, nothing's ever perfect, but we made some really good improvements to it. The library's website is separate from the self-service center. We need to work on integrating those, and we will. But there's a lot of information on our website that's in little bites and pieces that are good, quick takeaways. One of the things that you'll see a little further down on the screen is self-help and educational videos. Oops, there we go. And we do have quite a few YouTube videos that we've been working on. I think that the videos are great. It's getting the videos to the person when they need them. That's the rub. And we have made some great videos. We just haven't, it hasn't had the synergy yet of us being able to place them at a point where the litigant is going to be able to access those at a time when they need them, at the point where they're ready for that teachable moment, because they don't want to watch a video unless they're clear that there's a need to watch the video. Otherwise, they will want to just try to move on to the next step without assistance. So we're hoping to embed these in our self-service center website at places that will make strategic sense, whereas right now we just have them listed here, and they're available on our court's YouTube channel. I did mention Easy Court forms, and I did a screen capture here of our homepage for that. This is unique to us. We do spend a lot of staff time on this. Our IT department supports this for us in-house. It's not a application that we purchased. It's homegrown. I can't say that I don't know that I would recommend, because of the time investment, trying to do this. I would be more inclined to use one of the A2J authoring software, some other things that are out there, because of the labor intensity that's involved with this. And also, I actually have to go through IT to get updates done. It's not something that I can use in a user-friendly manner, go on and update ourselves. But I will say that we've collaborated extremely well with our bench on this, primarily because our presiding judge is a huge advocate for technology and really wanted to see this happen. And as a result, we have a lot of modules. I admit that I haven't looked at other courts thoroughly, but I have to guess that we probably have one of the largest intelligent forms of any court out there, intelligent forms libraries of any court out there in the nation. We're about to create some probate form modules, and we also are getting ready to do a name change module for civil court. But basically, any pre-decree family court process is going to be able to be done on Easy Court forms, to the point where our family court should be, the next couple of months, making a decision to pull our forms that we have in PDF off our website and funneling people into Easy Court forms on a, I hate to say forcing them, but that is really the best word to use, forcing them into Easy Court forms. What the judges like the most about this is that it forces the quality of the forms, and the output is assured. Whereas if you have a print form, somebody can leave information blank. They can write things that are that you can't read in illegible handwriting. Maybe they misunderstand the question and put the wrong thing in, whereas they have a little more quality control with the intelligent forms. So it'll be interesting. Anecdotally, I will say the last time we did this project, we did a pilot where we forced people into Easy Court forms. We did get a nice letter from a local watchdog agency well, actually I should say it wasn't a nice letter. It was a very mean letter, and they were not happy with us, and I think there was a lawsuit threatened, and we put the forms back online. But we've done a lot of different things now, and also the intent is this time to still leave the print for sale in our centers. So that's a high-level overview of Maricopa County, and I think what I'll go ahead and do now is pass things off to Lisa to talk about Travis County. Oh, actually, Marcus will probably want to introduce Lisa.
No, please come on up, Lisa. Great. And I'm going to just tell Jennifer, it seems like she's been a little busy. What do you folks think? Yeah. It's remarkable. And as a former colleague, I can just tell you, Jennifer is so committed on all this. So Lisa's from a small county, Travis County, okay? And I think you're going to be surprised. It's actually a huge system there. And we're just really pleased to have you here. So Lisa, jump in, please.
Okay, thank you.
Well, no, that was my feeble effort at humor, okay? Yeah, so, okay.
Thank you.
Thank you, John.
It's small compared to Maricopa.
Well, no, not at all.
Thank y'all for inviting me to speak. My library, our reporting structure is different from Jennifer's. She is part of the courts, and we report to the executive branch, the Commissioner's Court. Our funding is through civil filing fees. We get $35 anytime someone files a civil case in Travis County that's not a tax foreclosure. That's why we encourage divorces. Also, we have just started recently getting some general fund money. We had to show that the library provides a service that saves courts time, and we did that. And now the library is actually getting general fund money, which I understand is kind of strange for libraries. We're also unusual in that we're doubling our space and we're increasing our staff. So the Travis County Law Library, we still do some of our traditional things, you know. We still are the centralized purchaser of the books for both the courts and the library. We're the centralized contractors for Lexis and Westlaw and password administration for the county. We still do legal research. We do all of that. But we have something new for Texas. And it's actually 12 years old. We have reference attorneys, and now we have forms. If y'all walk away with something, I want you to walk away with this. Forms happen. And you can't control what people walk in with. They just happen. The best you can do is put out the quality that you want to see. Now, the libraries are in the business of providing information so our patrons can make decisions. That's so our pro se patrons can make decisions, our attorneys' patrons can make decisions, and so our judges get the information from the attorneys and the pro se so they can make decisions. Reference attorneys and forms are critical for that. This is how it works. A reference librarian conducts a reference interview in person or by phone. Now, Marcus talked about triage, and every time I hear the self-represented network, Litigants Network, use that term, I laugh because it's just a reference interview. We've been doing it 100 years. Mm-hmm. So a reference attorney, a librarian, interviews the patrons. And it may be that the person needs forms that we have right there that we can hand them to them. No need for that patron to go up into the courthouse, to go to the clerk's office. We have what they need to go away and fill out the forms and bring it back. It could be that there's nothing in the library or in the courthouse that can help them at that time. And we are a depository of information about referral services, hotlines, clinics, non-legal, frankly, services that people can access. Legal research. I'm going to talk about pro se litigants who we can help because we have the forms and the reference attorneys who can help them. But there are still some who we can't help. And for those, we are still a library with form books. Part of the duty of a law librarian is to rip off rose-colored glasses. Some people think they can do, some pro se litigants and represent litigants don't understand the value of an attorney, and we show that to them. We show it to them gently. We show them what the attorney went to school to learn that they're going to be expected to know. A lot of people leave the library more willing to hire an attorney because they now see the value. It's not someone telling them, you need to get an attorney. It's us showing them why they will benefit from hiring an attorney. So I learned recently that of our lawyer referral program, the highest number of referrals come from the Travis County Law Library. So our self-help center / library is not in competition with the bar. We're a supplement. So appointments with reference attorneys. We have a program called reference attorneys. They are attorneys who work for the law library. The attorney can review an unrepresented litigant's paperwork prior to them attending the uncontested docket. The point of this is that the litigant shows up at the uncontested docket with hopefully their paperwork fully filled out. After they get to the uncontested docket, they see the reference attorney again. This time, the reference attorney reviews the forms before the litigant gets up to see the judge. And the reference attorney fills out this checklist on the right. Because the attorney fills out this checklist on the right, and the judge trusts the attorney for what they put on the information on the right, it can really speed up the process of that judge looking at those forms. The other thing the reference attorneys do is they create forms. Good forms are essential for your judges. There is something called muscle memory. When you get used to looking at certain information in certain places, you become more efficient and you don't look at it. An example is when you move your mouse to check your email. You don't even look on your screen to open that folder anymore. You just do it naturally. When you have good forms that judges are used to seeing, you make them more efficient that way. So that means the information across revisions of forms are consistently in the same locations, and that the judges see the same forms. When we put these forms up on our website in 2002, they were used all over the state. Not by our intention, but because forms happen. So eventually we put them up on Texas Law Help. Those forms have now been downloaded tens of thousands of times in a year. They were the foundation of the forms that the Supreme Court used to create its divorce forms. And I have to argue with David. The family bar was included, and they were invited, and they served on the committee, and I got proof. Okay. Jennifer was right. It takes a full staff member to keep the forms updated, and it's more than we can do to keep them, to automate them right now, but it does take that much. When we started this in a pro se committee in 2001, when we started thinking about all of this, we did have a member of the bar, family bar included. And then when the reference attorneys first started meeting with litigants, they met with them in the library. And as one member of the bar put it, the Travis County Bar members can recognize a walk-in accounts receivable when they see one. And I think that's why we didn't get much pushback in Travis County. They saw who we were helping. Another thing I want to bring up at the bar is in Texas, the code reads that a law library can be governed by a committee made up of the members of the bar or by the Commissioner's Court. I'm very fortunate that it was our library reports to Commissioner's Court. I think Texas is fortunate for that. I don't believe that members of the bar have the incentive to help pro se litigants get the information they need. And for the legislation that says that the members of the board must be made up of attorneys, I think that's short-sighted, because if you're going to have a library board to help everyone in the courthouse, you need to include court clerks, you need to include public librarians, technologists, court administrators, not just members of the bar. Because I do think we librarians can help y'all do your jobs. Okay. The last screen I want to show you, next to the last screen, is how the library can be a connection point. So in the upper left building, that's our civil courthouse. Texas Rio Grande Legal Aid, they manage one of our court clinics, one of the clinics that we frequently send people to. And they send the folks back to us. They are a place we make referrals to, and they refer to us because they can't help all the people who come to them for help. But they know that if they send someone who has an uncontested family law matter, we'll help them, or an occupational, or a name change. Okay, Dispute Resolution Center. They entered an agreement with the law library that if we make a referral to them, they'll waive all their charges. The reason we think that's good is because we have some pro se litigants who are not agreed, but they're almost agreed. So if we can push them one step forward to be agreed, then they can come through our program. And lastly, Texas Law Help. They've been our biggest and best partners. They publish our forms, and they have served as such a tremendous resource for all the county law librarians in Texas. What's next? Well, we recently started attending the night clinics one of our reference attorneys have. And the reason we were interested in doing this is because people would come to the reference desk, we would refer them to the clinics, they'd go to the clinics and be told they needed something, and they'd be right back to the reference desk. Why should they have to go on that merry-go-round? So what we're doing is creating prescription pads that those clinic attorneys can use to check off what they want those pro se litigants, what forms they want them to have. And then those litigants can come, or they can call us, or they can email us, and we'll send them what they need. So I think the theme of this conference is the courts from 10,000 feet. I got some predictions for 2025, 2035. My prediction is that law libraries won't exist. They won't exist if they don't embrace services to pro se litigants, because otherwise their patron base is gone. It's not there. And any librarian who doesn't see that is a fool. Any librarian who's still spending tens of thousands of dollars on reporters while she has pro se patrons in her library asking for forms is a fool. She should cut those books, redistribute that money to hire an attorney to write the forms that her courts needs. Okay, so next thing, filing fees for libraries may not be enough for a library in your county, and it may not be enough for a library in the next county. But couldn't several counties pool their money and create a regional law library, even if it was a distant services library? Couldn't a state law library pool the funding from counties that don't actually have physical library for those county law library fees, and in turn provide library services remotely from the state law library? Surely that would fund a position or two to offer that service. And my last prediction is a hope, and that is that law libraries who do reports to boards, that those boards be diverse, that they include you, that they include court clerks, that they include public librarians, that they include legal service providers, that they include judges and members of the bar and members of Commissioner's Court and members of the Planning and Budget Office. That's it.
Yeah, Lisa, thanks so much. Your program is so impressive, honestly, and then you're looking to the future, I think, is so helpful. And it sounds like a challenge to the librarians, but I think also to the court managers here, too, to try to kind of shape that future. So just wonderful. I've got just a few more questions for the panel, then we're going to go ahead and open it up for your discussion. Heard a lot about technology, and Jennifer, you were kind of teasing us a little bit, I think, with this idea of YouTube channel and so on with the court. Could you share a little bit more about that with the group?
Yeah, absolutely. Our court actually has a Facebook page and a Twitter account, and the library isn't able to have their own because the court wants a unified social media presence. So we do post content to the Twitter and Facebook pages. I had to, harkening back to our speaker this morning, if you probably want a really interesting look at the court and Twitter, you could go back to our court's Twitter handle, which is @CourtPIO, and look at everything that happened with us in the Jodi Arias trial. Well, it's probably still going on to a certain extent, and I don't know whether it's what not to do or what to do, but it would be interesting. I haven't even gone back to look at everything, but I know that there was a lot of Twitter conversation out there. But we also have a law library blog, which is our own, that we've carved out, and we're really starting to, it's been about a year now, we have 100 followers, which for a blog, I mean, I know it sounds low, but we're proud of it. But the YouTube channels, we have a media office. We're blessed to have a media office that is able to support us with some technology, video cameras, intern to shoot. But I do the scripts. It is something where even if we didn't have a person, there's still a lot of software where you can do recordings of your own videos and not have to do a talking head, but you can actually record what's on your screen, which is sometimes even better than a talking head, because it's easier to edit after the fact if you have wrong information, which is invariably going to happen with videos. So I think that there's a lot of different technologies that are out there, and the librarians, and I will say that not all of them, but I think Lisa's challenge to librarians, I think I'd match her challenge with a challenge of my own, which is that, for me, a librarian's true value comes with adding the knowledge of technology to the conversation about information. And I know that not all of our librarians have that skill set, but if they don't, they should be developing that and learning how to use those technologies. They know how to use complicated databases like Westlaw and Lexis, and to learn how to use a Camtasia, which is a recording software, is not a huge leap. And so I encourage librarians to adopt technology, because I think that is the kind of the wave of the future for us. And I know there's a lot that we can do, and it's surprisingly easy once you get started with it. I mean, the YouTube videos don't take me really anything to put together now. I mean, within the span of a day time total, I mean, not even a day, probably, half a day, we can have one done from start to finish if we put all the amount of time we spent together on it. So it's pretty quick.
Yeah, Jennifer, good. David, please jump in.
Just to make sure. Oh, thanks. I'm not going to spend a lot of time, but if you're interested in looking, our office, the Office of Court Administration, has just in the past year put up a website called, it's obviously coming off of the Texas Law Help, it's called TexasCourtHelp.org, and you're welcome to all go on there. If you click on the civil and criminal at the top, you'll see we have posted videos on every process of the court, giving people just short snippets of how they can interact with the court. So I think the videos are something that are helpful, and they're out on our YouTube channel, but they're also on TexasCourtHelp.org. So that's another thing that people could access. And if they're in Spanish and English, and if any of them are applicable to your court and you want them, we'd be happy to share them with any of you. You could take them and use them yourself.
Would you be a star in any of those films by chance?
I am not.
Okay, David's not online. Okay.
I don't speak Spanish, so that was the problem.
But I think those are great resources. And what I noticed in what Jennifer mentioned, some of these are really pretty hip. They're quick, they're kind of fast-paced, and I think they really would connect with maybe the younger generation, a lot of the court users. And it's so different from in the past. We would kind of have the PowerPoint kind of outline and the detailed instructions and whatnot. But these are what, 30, 40, no more than 60 seconds, but just cover a lot of ground. And so
I try to be short and succinct.
Yeah, and it's really worth a look. My funniest recollection on this was that they had this backpack journalist from the Cronkite School of Journalism, and she came in the office one day and said, "I'd like to do a story about the new escalator at the new courthouse." Okay, and we thought, what? Okay, it was the first escalator in the downtown complex, but it's crazy how they could turn that into another way, sort of hip stories that would make an interesting coverage, maybe on a slow news day, I guess you'd say. But I'm going to just switch gears a little bit. Lisa, you talked about the stakeholders and the committee process, and I love that you said the court managers and so on ought to be included in the governance. But for these folks here, when they go back to the courts, how best should they work with the library system, whether it's in the court or executive branch or even the public library, if you will? How should they go about that?
They should ask her out to lunch. And then they should just start a conversation. Then they need to actually help with the library, develop an angel for the library. Librarians don't have a lot of power. We don't have a lot of influence. We can get a lot done because we're pretty darn good worker bees. But we do need that angel. And if y'all could be our angel, that would really help. Because I think librarians are a helping profession, like nursing and educators. Because we are, people trust us. They sense that we are neutral. but we also have something within ourselves that makes us want to provide good service. And I know y'all want to provide a good service. And that's a link we have together.
Thank you. It's just that convener role, I think, really, where the presiding judge or the court manager, you're in such a good position to bring together a group like that, and then you've got this fabulous resource, sometimes right in your government complex. And maybe you all are doing that right now, but I know I never thought about it early in my career, honestly. It was just a bunch of books and kind of very specialized research, and I think you've kind of helped open up our eyes.
Now that y'all have met Jennifer and I, do you still think of books when you think of your county law library? Do you think of videos and forums and collaboration? Maybe?
Well, I see a few heads nodding. And then I just wanted to, I guess my last formal question really would be maybe to David. I know you've done so much work with court tools and so on. How does all this fit then with, let's say, the court tools measures, but even this high-performance court framework, National Center? Could you just talk about that a little bit?
Sure. As you all may be aware, the Core Tool 1, the first of the core tools, is on access and fairness. And obviously, how we assist people has a lot to do with it. If you go back and if I asked you all, maybe some of you would know the answer to this already from having done the research or being around in courts, but if you go back and ask most people who work in courts, out of the people who visit your court every day, how many would be happy and how many would be unhappy as they left? Most people will say it's 50-50 because 50% of the people who win will be happy and the other 50% who lost will be unhappy. But yet the research consistently shows that is not at all true. What the break line on whether people are happy leaving or unhappy leaving is whether or not they felt they were treated with courtesy and respect, treated fairly, and had their opportunity to be heard in court. And everything that we're talking about today all influence every single bit of that. If they walk in, as I said when I first started, if they walk in, they feel that they're not treated fairly or disrespectfully or whatever else, they're obviously not going to feel like the court was a place for them, that they actually got a fair day in court. And so obviously when you're looking at trying to measure the performance of the court, satisfaction of litigants has got to be somewhere up there in the top of what we're doing, or else they'll go find some other way to resolve their disputes. And obviously our goal at the end of the day should be to make sure we're providing the best service. So I think that has a lot to do with it. And then when you start looking at if you look at the high performance court framework, it's all about internal and external stakeholders and their viewpoint as well as their perspective on it. And all of those measures around that are directly applicable. And you can make a stretch real easy to some of the other measurements, such as time to disposition and age of pending cases and all the other different measurements of how effective the court is. If unrepresented litigants are not getting the information that they need to be able to process their cases through the system, it's going to slow everything down, including the court process. One thing I was thinking that I wish I would have said, one of the main reasons why in Lubbock we started looking at this issue was the amount of time judges are spending on this. Lisa kind of hinted at this, that they're helping the judges in Travis County with the checklist and reviewing forms ahead of time, because when judges are on the bench and they're having to do that, there are a group of attorneys that are charging hourly rates to their clients sitting back in the back of the courtroom waiting while the judges are working with unrepresented litigants to resolve their cases. So the more we can do to assist these unrepresented litigants as they come into the courts, the better the process is for everyone. It's not just for them, it's for everyone. And expedition of the cases is part of that. So I think it does have great applicability to really the entire management of the court. This may seem like a really just small piece or maybe even a decent sized piece of what you're doing, but I think it really does have broad application across every facet of how we manage our courts, because even if it's just dealing with them, it has some impact on the clerk's office, the judges, the court staff, everyone else who's dealing with them. And if we can give them the information that, number one, they can either find themselves and resolve their own issues by information that we're able to provide them online or in some other form, or if we're able to give them some sort of personalized service, obviously it expedites the whole process.
Yeah, thanks, David. I know a lot of you had worked with Ernie Friesen in the past, professor in court management, and had always talked about prepared lawyers will settle cases. And if you think about it, prepared litigants will settle their cases as well. And really, that's where I think the law library comes in such a good way. The other thing I've noticed when it comes to the measures and whatnot, librarians love to count things. It's incredible. I mean, and so they will count. I know Jennifer has a very detailed count on the number of forms by case type, by court location, that type of thing, service hours, contacts at the phone, and that type of thing can be really helpful, I know, for funding with your funding bodies and so on, and it really works well, I think, for strategic planning. Before we actually go out to the audience, I want to just have John kind of share with you an announcement, an opportunity, I think. And I think a lot of folks know that John Grecian's a consultant, has done a lot of work in this area, and actually I think had really one of the key articles years ago about giving legal advice to the staff, the role of staff. So I don't want to steal your thunder, John, so just share this with the group if you would.
Thank you, Marcus. The State Justice Institute has given the Self-Represented Litigation Network. How many of you know about the Self-Represented Litigation Network? Not enough. The network is an organization of organizations that have an interest in services for self-represented litigants. It's sort of the professional home for people who are providing self-help services. And we have website, working groups, listservs, discussion groups to solve the problems of people who are day-to-day providing assistance to self-represented litigants. Back to my topic. The SJI gave a grant to the Self-Represented Litigation Network to look at how 3 states, California, Oregon, and Minnesota, have entered into cooperative agreements with the Office of Child Support Enforcement entities in their local state to get their services to self-represented litigants in the area of paternity and child support reimbursed through 4D funding. The federal regs allow the local child support enforcement entities to enter into these cooperative agreements and reimburse the courts up to 66% of the costs of the services provided to self-represented litigants in paternity and child support. There are a number of courts that are taking advantage of this to fund the judge. You can't use the word judge. It has to be a non-judge, a commissioner, magistrate, special master. But if the child support work is done by someone other than a judge, you can get 66% of that bench officer time reimbursed as well. How many of you are doing that? Be aware that you can also get it to reimburse your self-help services. And that's the way California built its system to begin with, was through this 4D funding. And the funding is not limited to 4D child support cases. It's any child support case, and the rationale there is that to the extent that people are getting the non-custodial parent, the custodial parent is getting child support, then there's a less chance that they'll end up on welfare. So it works both ways, reimbursing for the welfare already put out and preventing other people from getting on welfare. The network has a resource guide that's just about ready for publication. And we also have technical assistance services available for people who are interested in exploring this in your community, how to get this money. You think about it, if you could get 2/3 of your current program paid for by someone else, that gives you that much more money to expand your services. Thanks very much, Marcus. We're going to have a special interest group at the annual meeting in Scottsdale this summer on self-represented litigants, and we'll talk further and have copies of the resource guide at that time. But if anybody's interested in this technical assistance, the grant actually is over by June, so we need to get that TA put out in the next few months. So contact me. My email is john@greacen.net, GREACEN.
Yeah, thanks, John. It sounds like a great opportunity. If anybody's stuck in the airport, you can start working on your application. How's that sound? Yeah. Listen, folks, I know it's late in the day, but we have about 15 minutes, and we have such great resources up here. So I just want to open it up for any questions, comments, ideas. I think Lisa really kind of painted two views of the future, and I think you really give us a lot to think about. So let me just open it up to you folks, and fire away, please. Yeah, please, David. I'm going to bring this back because we are, I guess, recording here, so go ahead, please. And you're a journalist way back when, right? So, okay.
It's all behind me. This is maybe broader than just what's available at libraries, but we've been wrestling in Indiana with whether or not we should provide petitions online for the child custody portion of a divorce, and our judges have really resisted this, and so we'll do almost everything else in the family law area, but we won't give them a packet or print forms for, you know, setting up the initial child custody. I just wondered how the rest of you react to that.
I guess I would echo Lisa's statement about forms happen, which is very accurate. And for some reason, judicial officers will resist certain forms. And for example, I cannot do a motion to appear telephonically because they're afraid if we build it, they will come and everybody will be wanting to appear telephonically. But in that instance, I mean, I would rather engage in quality control and have the form be something that's acceptable. I know one form that we did pull down was a non-parent custody petition because it was being misused. And that was probably the only time that I really saw something happen, and there was, I think, a really good reason for not having a form available, and we were working on correcting those issues. But it just seems like that's going to happen one way or the other. And I don't know, Lisa or David.
I agree. It's a situation we're having. Hopefully, this is picking up, but. The situation we're having in Texas, where there's resistance to forms that are sort of state Supreme Court endorsed forms. Lisa was talking about all the forms that they put out, but what's happening in the places where there aren't these Supreme Court endorsed forms, people are getting forms. The problem is they're getting forms that aren't applicable to our law. They're going on Google, they're going to Barnes & Noble, they're searching for these forms and they're paying for them, and then they bring them in and the judges have to spend 10 times as long working with them. And I know in Lubbock when the judges were doing it, they would look at a form, and of course the judges can't give legal advice, so they're telling the pro se litigant the form doesn't comply with the law, and they give it back to him. And of course the litigant's question is, well, what doesn't comply? Well, I can't tell you. So then they try again, and they bring it back, and it still doesn't comply. And so wouldn't it make a lot more sense at the end of the day, if they're going to get the forms, and I like the term of forms happen, if they're going to get the forms, they're going to bring them in, why don't we give them something that at least they can start with something that is at least based on our law? They may still not get it right, but they're going to be bringing it anyway. So my position is we ought to be, providing the forms to them to the point where they're actually using ones that actually apply.
Be aware that there are a number of states that do have the full panoply of divorce forms.
Yes, we see those all the time.
One thing that I have seen reported is where they have just the form for no kids, that people with kids will use it, and then they will actually get a decree that does not recognize the existence of those children. And then the other parent runs off with the kids, and your official form says you don't have any kids.
Let me just ask Lisa, did you want to comment on this as well, please?
Just that I think your judges are missing the opportunity to get the information they need to make a decision. Because if they help design that form, they can make sure that their questions that they need to ask are answered there in that form.
Thanks, Lisa. Other thoughts you folks have? Yeah, please. Yes, you were on this morning, I think. Is that right? Yeah, you were. She did a great session this morning on social media, so it's great you're here this afternoon. Go ahead, please.
I was wondering if the prescription form that you have is like a case type specific. I love the idea of the prescription pad where the attorney checks off the forms. Are they case specific, or do you have one that's just a general one?
Those are our most frequently requested forms, but we're about to expand it to include everything, including the kitchen sink, and give those kitchen sink prescription forms to all the legal service providers in Travis County who work directly with people. That way they have our list. Also, all of our forms, not just the ones we put on Texas Law Help, but the ones that we've created for in-library use, we put on the website called Texas Lawyers Help. That's different from Texas Law Help. Texas Lawyers Help is used by advocating attorneys. So it's used by attorneys. They have access to a lot of forms. We just haven't put out there for statewide use.
Very Dexter, please go ahead.
Jennifer and Marcus, we'll talk more about this. How did you get consensus on what forms are appropriate? Because each judge, each judicial officer may want to see something a little different, and so how did you guys? How does Superior Court get consensus on this is the form we're going to use, not your personal preference form?
Yeah, that's a loaded question, but yeah, Jennifer, please.
At one point, we did have a forms committee, and woe unto the form that ends up in front of the forms committee. And this was before my time. In the end, we have adopted a model where it's our presiding judge who will or the departmental presiding judge who will make the decisions, because you're absolutely right. If you have 26 chiefs in the room, everybody's going to have a decision on they want to see something different happen, or what's more likely to happen is they just each want to make a change to the form because they each want to have some finger in the pie, and but so you've got to put somebody in the position of making that final decision.
I would just agree. This goes down to a governance issue, and it's something important for all of you if you're thinking about this type of project to consider. Lisa, I don't know if you remember, I don't know how long our forms were before committees, but it was probably 2 years, and it was just the uncontested divorce forms with no children and no property. So, I mean, really and truly, if you're thinking about this, you really ought to think about a governance model where someone can have the approval authority for them to be used, because otherwise, if it's gone through a committee structure, or even if it's at your court and all the judges have to approve it, chances of getting a unified form, as with any form, we know even internal forms, we'll have 3 judges use this one and 4 use that one and 2 use this one because they all have their preferences. So, I think it's really important to think through that governance ahead of time. And if you choose to do the committee, fine, just be prepared that it's going to take a lot longer to get that done, and there may be issues.
So David is right. It took the Texas committee 2 years to approve a form that had been in use publicly for 10. There's another one major benefit of centralized forms and funded forms development is you don't have to rely on the library making its best judgment. And one way that we decide what forms to start out with, to prioritize, are the ones that get the Sharpie treatment in the courtroom. If a judge is in there crossing through stuff with Sharpies and writing stuff in the margin, those are forms that we know need our help, and for pro se litigants.
Yeah, and I'll just mention too that in Maricopa, that Easy Form project became pretty complex, and they had just a battalion of judges and I guess 2 or 3 attorneys working on that, and it really changed. It was interesting, and I think Jennifer's right, a really interested presiding judge, one guy from the webmaster group, and then maybe 1 staff, and so they went from about 18 people at the meeting down to about 3, and I could just watch this. All of a sudden, these really kind of fabulous flow charts, and it started to really come together, and things started to move much faster. So certainly you need consensus. You want to include the stakeholders, but for that kind of a detailed project, to get any momentum, I think it had to move back down to that level, and we've been fortunate that way, I think. Another, please, thank you. Go ahead. We'll get Sarah, then we'll come right over here. Thank you. Go ahead, Sarah, please. Go ahead.
I'm listening, and I'm wondering, it sounds like this is happening court by court. And I wonder if there is any movement afoot or any initiative through the state court administration to start developing some forms. I know they'll be different state to state, but some kind of standardized document that could be utilized adapted and utilized in each state. I'm thinking it's probably going to have to come from the top up, which is why I'm asking about the State Court Administrators Association, something that would work its way into each state, because I have found, and I think most of you know this, that courts can be very hostile to self-represented litigants. And that if something started coming down, then we wouldn't have all of these little individual things, which are wonderful, but it might give us a framework to move.
You know, thanks very much, Sarah. Yeah, and David, I guess you're the state court administrator.
Yeah, so you're referring to COSCA, Conference of State Court Administrators, and also the Conference of Chief Justices. I can tell you that both of the conferences just recently passed resolutions in support of self-represented litigant projects. And they continue. I think every meeting I've been to with COSCA or CCJ, there have been resolutions adopted regarding that. I don't know of any, and maybe John can help, I don't know of any specific project that is doing what you're talking about, which is sort of coming up with a standard, that these are the basics at least to sort of start your project with. And that's an interesting concept that would perhaps push this forward, because part of the issue is it's kind of an overwhelming task to think about starting from scratch. And if there was at least a basis, a basic framework, it might actually push that along. It's a great idea. Thank you.
Thank you. Had a question over here.
I did. And this would be for Jennifer or Lisa, about educating the public on what's available in your respective libraries. Has there been any push that you know of by you all or your colleagues to maybe spread things out a bit away from the traditional courthouse model library to maybe partnering with your local libraries electronically, some sort of way where folks don't have to travel to the local courthouse, that they can access documents and such either from home or from a local library, be directed to a page that has some of the information that might be beneficial to them. It seems like, at least in my jurisdiction and others where I've worked, we're kind of, you know, hunkered down. Everybody comes here, we help them or we don't help them, and then they go from there, versus in their local community, instead of traveling a half an hour across town to get here, when they could have, you know, did it from home, or they could have accessed a portal at a terminal there in their local library where there's plenty of computers, and may have reached gotten some of the same information that just like they would if they came to see one of you all.
So there's a librarian named Sarah Galligan in Minnesota, and she used to be the county law librarian for Ramsey County in Hastings, Minnesota. Now, Hastings, Minnesota is the county seat, but it's a small town away from the population center of that county, which I think is closer to Eagan. I'm not real sure. So what she did is put a county law librarian in the public library. They gave her space. The county law library provided this staff and this person. And then the county law librarian also trained someone to be there after 5 o'clock. Because, you know, like Jennifer said, the library's open more than 8 till 5. So that was wonderful. They did something similar in Orlando. My own library, we've gone around to the libraries in Austin, Texas, to train them on Texas law help and to train them to have their patrons call us. You know, that's been pretty successful. I do believe librarians, public librarians, should be included. They're getting asked these questions too.
David.
I just want to add one thing here, and I'll end it with a challenge, but you've heard mentioned a number of times TexasLawHelp.org. If you go on there right now, I just pulled it up. In the upper right-hand part of the screen, there is a button that says need help finding information, chat with someone who can help you. If you click that button, then you connect with an attorney on the other end who is staffed 8 to 5, Monday through Friday, who will actually answer questions and chat with you. And I think we have to start thinking about this, because I agree with you, Edwin, that it doesn't make sense for us to continue the traditional model of thinking people need to come to us. They need to come to us in remote ways. And you probably heard this morning, this is the challenge for all of you. you heard this morning Jonathan Mattiello from the State Justice Institute talk about their new strategic initiative grants regarding remote technology. And I asked him last week, I was with him at another venue, another meeting, and I said, well, what kinds of things are you looking for? And he said, that's the question that we have for all of you. And he was talking about, you know, they're wanting to fund these things, but they're looking to the community to come up with what the ideas are. You know, Lisa's comment earlier about, rural areas collaborating together and having coming up with a program where they could provide help services through the law library or self-help center somehow remotely. I mean, there's a lot of potential out there, and I think we can. The limits are as far away as our creativity lets us go, and we can go there. But I think we have to start thinking about that. About how can we give the services? Because once again, these are people who don't have time to come to the courthouse 8 to 5 Monday through Friday when we're open, and we have to find a way to be able to get the services they need. And the one thing that hasn't been mentioned today that we also ought to think about and how we can link this up remotely is the limited scope representation or unbundled services where attorneys handle, because the other side is there are those people who they can't do it on their own, period. They just can't, no matter how much help we give them. But they don't need an attorney for every piece of their case. Maybe they only need specific assistance. And there are a lot of attorneys who are doing this, but there are a lot who have not embraced this concept of limited scope representation where they only help them with specific pieces and then the individual does the rest. So maybe it's just forms review, or maybe it's the temporary orders hearing of a child custody case, or maybe it's only child custody, but we're not going to help you with division of property or child support or other things. We need to be trying to use our judges and ourselves as collaborators to talk to the bar about being able to embrace that, because I think it has a lot of potential as well.
David, I was going to say I've talked about this as well, and the big fear that I hear from the legal community is that once they engage in limited scope, the judge is going to hold them accountable for the entire case. And what I think would really boost this, at least in Texas, is to have rules or something that says if you sign a limited scope agreement with a client, that is your only responsibility. The judge cannot force you to go outside that agreement.
If you look in Montana, you'll find exactly that rule, along with some other rules to implement the unbundled practice. I just wanted to say to Sarah, the network has a forms committee chaired by Glenn Rawdon of Legal Services Corporation, and they're working on strategies for forms deployment, which almost always focus, as you're suggesting, at the state level, with forms that they don't have to replace every local form, but every local court has to accept the state form if it's tendered. And just final note, the network is doing a project with SJI funding on remote delivery of services to self-represented litigants. We'll start that in April and be able to report to you about it at mid-year.
Thank you, John. And I know that it's getting late, and I just think you folks have been so attentive and so thoughtful, honestly. And our panel, I just want to thank these folks for just the great inspiration they give us. So.